Mary Ann?
Yeah? Is yours?
Yeah.
Good evening, Judge. So I'd like to begin very briefly with a prayer that our nonviolent witness to stop the killing of other brown people on the other side of the world by drones at Hancock be an offering to healing begun by the two-road wampum renewal, reminding us to honor treaties made by the Six Nation Confederacy here and honor the global treaties created for peace for all peoples. So greetings, Judge Gideon, Mr. McNamara, Scott, Colina, and Pat. Tell me your name again. Paula. And all of you who are here to serve the people and provide us with due process. I thank you for all believing in this process and dedicating your life's energies to this fundamental process of democracy. Due process is something that drone victims are denied. And Judge Gideon, you know I was one of the Hancock 38 defendants who stood before you from November 1st through the 5th in 2011 for 45 hours of trial. And on the eve of that first trial, on October 31st, which happens to be my sister Ellen's birthday, Halloween, while kids were out trick-or-treating here, there was a drone strike in Pakistan that killed 16-year-old Tariq Aziz, and you've heard of his story before. So it killed him and his 13-year-old cousin as they drove to a soccer game. Over 4,000 people have been murdered by U.S. drone strikes, and Tariq is one of over 300 children that have been killed by drones. And 98% of drone strikes kill civilians. And killing Tariq hasn't made us any safer. So today I wear this t-shirt with his photo. As I watched the film Unmanned, America's Drone Wars, when I saw Tariq playing soccer with his teammates, it reminded me of being at the soccer field with my own 3 sons and daughter, who happen to be Guatemalan and Irish. So they're dark. They're not as fair as I am, or most of them. And they look like Tariq. And so as a mother, I'm horrified at the thought that another mother's son was murdered, and that Hancock is responsible for the murder of children by drones. So on December 12th, the day that we were supposed to start the trial, a wedding party was hit in Yemen, and I can only try to imagine the pain that the families are feeling. And the horror is that this pain is being multiplied throughout many countries due to U.S. drone strikes in the never-ending war on terror. And when I learned that drones were being piloted from Hancock Air Base, I knew that I, like my co-defendants, had to go to Hancock to call a halt to this war crime, upholding our U.S. Constitution, Article 6, Section 2, in relation to the codified treaties that the U.S. has signed on to, and that our U.S. Senate has ratified, specifically the UN Charter and the Geneva Conventions. It was ratified, the UN Charter was ratified 89-2. And the International Civil and Political Rights Covenant, Article 6, which codifies the obligation of the United States to respect the right to life of people at home and abroad. These treaties that the U.S. has publicly promised to honor state their intent as to end the scourge of war. And the current U.S. hidden and twisted reasoning for using drones clearly violates the purpose and the letters of these central contracts. The Vienna Treaty of 1968, which the U.S. has accepted as established law, says that these treaties must be honored in their simplest, clearest terms. These codified laws are the most important laws binding all human beings, everywhere, always. In addition, I cite case law from the Tokyo War Crimes Tribunal trial decision. Anyone with knowledge of illegal activity and an opportunity to do something about it is a potential criminal under international law unless that person takes affirmative measures to prevent the commission of the crimes. Furthermore, Judge Gideon, the U.S. Constitution does not require or contemplate implementing legislation for treaties. As a consequence of Article 6, the treaty clause, U.S. treaties constitute a source of federal law, supreme over state law. And this is established by the third restatement of foreign relations. The treaties, codified statutory law that are being routinely violated, are all self-executing, and they are therefore binding on all courts, including DeWitt Town Court. This is from Cornell Law Professor Chantal Thomas, giving detailed legal analysis in her statement on the judicial enforceability of international law. And she happens to be the current vice president of the American Society of International Law. So my intent in going to Hancock was to uphold law, never to break law. And as a citizen of this country, I'm responsible for what my country does. Judge Gideon, in your sentencing statement of December 1st of 2011, you wrote that you had had sleepless nights in trying to decide our innocence or guilt. So like you, I've also had sleepless nights. Because I know in my gut that the extrajudicial killings that goes on perpetrated in our backyard is a crime. And as I've shared it with this court before, many of you know that I make my living as a cook, as a caterer, and I normally deal with preparing food and serving people. So I'm not practiced with dealing with legal matters, but I'm willing and I'm capable and working at it. So I'm willing to stretch to figure out how to best to invite you to look more closely at the evidence presented, and I respectfully invite you to entertain a new understanding of your judicial role and the issues we bring before you. One thing that is obvious to me is that there is no way we, and I include you, Judge Gideon, in our circle, that we as a community cannot turn our backs and stay silent when murder is happening. And when we see something, we must say something and then do something. So I've been raised Catholic, and I've been taught to respect life in the tradition of what we call the seamless garment. Are you familiar with that term by any chance? Okay. I've been told that I need to qualify it, just to explain it, just to say that think of the garment that's one continuous piece of fabric, not made patchwork style, no seams in it. So this seamless garment is a way of looking at creative and just ways to support life from conception all the way to death. So it's the full arc of supporting life. So in thinking about this seamless garment theme, I thought much about how we all become comfortable in our respective types of work, our training, our thoughts, sometimes boxing ourselves in and really wanting to look at what we're used to and what we're comfortable with. So in thinking about the seamless garment theme, I've thought about your role as trier of fact in this trial. And it's obvious that these issues of violation of sovereignty laws, the violation of due process, extrajudicial killings, crimes against peace and humanity, and wars of aggression are not the issues usually addressed here in DeWitt Town Court, although it is becoming more frequent, as it should be. Tackling these issues may be a stretch for you, going beyond your comfort zone, as I am also going beyond what I'm used to. So in Notre Dame law professor Mary Ellen O'Connell's introduction to her book, The Power and the Purpose of International Law, Insights from the Theory and Practice of Enforcement, it states, international law compliance is the product of rule internalization. It suggests that this happens if international law rules are implemented in domestic law, enforced by domestic courts, and administered by government agencies. Judge Gideon, as you are indeed a believer in the worth of the law, and an applier of the law, and the trier of fact, then the law must be applied as a seamless garment, not disconnecting from one part, the international law, because it may be politically inconvenient for you or hard. We submit that the crime of murder is happening in this jurisdiction. So we came to Hancock Air Base as first responders, first responders, if you will, to the scene of the crime. And we invite you to apply the laws that our Congress has ratified here locally, upholding the systems of checks and balances that our Constitution created. Congress and the President ratify the laws. If Congress doesn't want these codified treaties in place, they can unratify them. But as long as they are in place, every judge is bound to uphold them. So Judge Gideon, I also recall you saying to former Attorney General Ramsey Clark that in the 2011 trial that your father had been at Nuremberg at the trials. So our co-defendant Andrea Levine told us that her grandfather, Jacob Lieb, who had testified at a trial subsequent to Nuremberg. Originally, she thought he had testified at Nuremberg. And then she learned after talking to family members during our preparation for coming here that he had actually testified later. But he told about how his whole family was murdered in the death camps. So our U.S. Supreme Court Justice Robert Jackson went to preside, as you probably know this history well, as the chief American prosecutor at the Nuremberg trials. So on April 13th of 1945, Jackson had given a major address at the American Society for International Law in Washington, in which he had advocated that such a trial be conducted. In his view, the victory about to be secured by the Allies in the most destructive war in human history should be ended with a civilized proceeding where the court of law would judge the guilt or innocence of major Nazi figures. I suggest that Justice Jackson would be aghast at the extrajudicial murder initiated by the White House Tuesday meetings that draws up the kill list, and then followed through by our 174th Attack Wing of the Hancock Air Base. And he would probably name it as a flagrant violation of due process. As I shared before, I ask you, Judge Gideon, that the law be considered as one seamless garment, applying international law within the local statutes here in DeWitt Town Court, upholding the citizen's privilege, and I was only corrected in the last week by Professor Boyle about the fact that it may be some of our moral obligation or an obligation by conscience, but under the legal status, we have a privilege and we are allowed to go and redress the grievances of the war crimes being committed at Hancock Air Base. That only those that have signed on to uphold the Constitution are obliged. That means everybody from Obama down through the air base to the lowest personnel there are obliged to uphold. So, but also we also ask you to consider how we co-defendants are not guilty on the local statutes of disorderly conduct and trespass. So this is my second half. So Judge Gideon, I do say that I'm very grateful for your patience with me during the trial. And now I address the specifics of the two charges I face in this court. So in considering these charges, as the court is aware, the prosecution bears the burden of proof. And I stand before this court, as do my co-defendants, innocent of the charges, since the prosecution has not proven beyond a reasonable doubt that either I or my co-defendants are guilty. As I have stated before, we have standards that maintain the integrity of the system for everyone, and you are the ones who maintain that integrity. These standards are the foundation of our legal system, and by maintaining these standards, you make sure that the foundation of the system is intact and not eroded beyond a reasonable doubt. So it's a very high standard, and that standard and burden was set so high for a reason, because it is the foundation of our legal system, and it is what protects everyone and all of us. And it guarantees that all defendants are treated fairly, and it's our standard and it belongs to everyone. And your duty is to ensure that the burden is met, and that the standards are maintained, and that you do not settle for less. And when you do consider the evidence here, you will find that the burden has not been met, and you must find me and my co-defendants not guilty. So the first charge is disorderly conduct. I would note that for the court, that by its own witnesses, the prosecution has admitted that the two of these gates discussed at the trial were already closed before any of us citizens bringing the war crimes indictment arrived on the scene. The gates were closed, and there were star barriers at the Thompson Road gate put in place by the military or base personnel prior to our arrival. Thus, the evidence is that the Thompson Road gate was closed by the military at some point, and therefore was not open to the public. These roads were already closed to the public. We did not block any road or gate at these two sites that were open to the public, and they failed to prove beyond a reasonable doubt the elements of the charge. In addition, there has been testimony that these roads and gates were private in nature and not open to the public. Therefore, neither I nor anyone else could obstruct the public from transiting roads that were not open to the public. To support the charge of disorderly conduct, the prosecution must prove that I or my co-defendants blocked a gate open to the public. But as I noted, the testimony of the prosecution witnesses was as followed. First, the two of the gates were already closed. Thus, these gates could not be blocked and traffic could not be obstructed into entering those gates. The prosecution was not proven that I or my co-defendants were involved in blocking any of those gates and obstructing traffic. They failed to show that I intentionally obstructed traffic at the open gates, and no one has placed me as a participant in obstructing traffic at the one gate they say was open. I'm charged at being at the Thompson Gate Road. That gate was closed and had star barriers in place before we arrived, and the prosecution has failed to meet its burden and prove beyond a reasonable doubt that I or my co-defendants are guilty of the charge of disorderly conduct. Nor can I be guilty of any subsection of Penal Law 240.20, disorderly conduct. I had no intent to cause any public inconvenience, annoyance, or alarm, or recklessly create such a risk. Quite the contrary. The officers testified that no one created a public scene or raised alarm. Indeed, the officers spoke as to how the defendants were cooperative and how they felt no risk or alarm in dealing with us. I also refer to court here in part to People versus Carcel 3 NY 2D 327, and that's from 1957. There the court notes that congregating, as used in the disorderly conduct statute, implies and is usually applicable to the congregating together of a considerable number of people. A crowd has been described as a throng, a multitude, or a great number of persons. That was not the case at the Thompson Road Gate. We were a small number of individuals. Also, I refer to the testimony of the prosecution witness, the DeWitt police officer, on January 23rd, 2014. His testimony was that he was sent to the Thompson Road Gate. He stated that he told the people there to disperse, and that, in fact, they did disperse when he told them, and he left. There was no testimony of any other order to disperse at the Thompson Road Gate. Thus, the elements are lacking, again lacking. Therefore, there can be no violation of subsection 6 of 240.20 for anyone arrested at the Thompson Road Gate. The evidence is lacking for any conviction under this subsection of disorderly conduct. In addition, I note that it is my recollection that no witness ever stated where I was when I was arrested. The evidence is that I dispersed after being told to. That is what the officer stated on January 23rd, that we all at Thompson Road dispersed. There's no evidence as to where I was standing when I was subsequently arrested. Nor is there any evidence to support any conviction of myself or anyone else under section 240.20, disorderly conduct. See also People versus Reed, 19 miscellaneous 3D 217 from Criminal Court, City of New York, Kings County from 2008. Judge Gideon, please note when the prosecutor makes his closing. He may make a number of statements about the defendants in general, but to convict me, he must address, and to convict any of the co-defendants, he must address all these points as they deal with each of us. Both the location and the situation in which I was arrested, or which my co-defendants were arrested. What happened somewhere else cannot be applied to me at Thompson Road. And when you review the evidence as to what transpired at the Thompson Road Gate, the evidence against me is insufficient and lacking, and you must find me not guilty. Trespass. I apologize if this is tedious. For those that are not used to listening to the legal ease. Let me address the second charge, and that is of trespass. The prosecution has failed to prove that I, or any of my co-defendants, knowingly entered or remained upon premises unlawfully. What's the evidence here? Merely being present at the scene is not evidence of trespass. No police officer could positively identify me. Judge Gideon, you heard the testimony and made note of that. There was no testimony that I or any other defendant, for that matter, entered beyond the fence or the gates to the air base. So the prosecution has alleged that people standing outside the gates and the fences were somehow on the property of the base. But there's been no evidence documenting that the base property extends beyond the fenced and gated area. In addition, the evidence is further lacking in that there is an inability for the public to know where the property of the base begins and ends. There are fences marked with U.S. government signs, but the prosecution is claiming that the base runs beyond those fences. But there's no indication or signs to inform the public of those parameters. There are not any no trespassing signs. The prosecution witnesses testified to that fact. Thus, there's no indication or way for a member of the public to tell, as claimed by the prosecution, that they have entered the private property of the base. The testimony of prosecution witnesses has varied as to the location of the base boundary. Some prosecution witnesses have stated that they believe the property line was the chain link fence. Others have stated that they believe that the line extended out beyond the fence. However, even these witnesses, and in fact all the witnesses, agreed and acknowledged that there was no line demarcating where the base boundary actually began. Therefore, there was no way for anyone, including myself or my co-defendants, to know where the actual base property began. There was, in fact, testimony by one of the military officers that he had advised that there be there needed to be no trespassing signs and other indicators, including signs to show where the property line was actually set. There's no way for anyone to know exactly where the base boundary was located and if they had crossed that line. Therefore, the element of knowingly entering or remaining is not proven beyond a reasonable doubt. Further, and more importantly, in my case, there's no evidence to prove beyond a reasonable doubt that I am guilty of the charge of trespass. Again, the prosecution has failed to meet its burden and prove myself or my co-defendants guilty of this charge beyond a reasonable doubt. Not a single witness could positively identify me as participating in the protest in a manner that would constitute a violation of this law. There is simply no proof beyond a reasonable doubt that I committed the offense of trespass. Finally, and this is the last page, I note for the court that the accusatory instruments charges two different criminal offenses in the same information. As such, the document is duplicitous and is in violation of Criminal Procedure Law, Section 230, or .30, and as such should be dismissed. Judge Gideon, the burden of proof on the prosecution is high and a great burden, and they failed to meet this burden. The prosecution has failed to prove beyond a reasonable doubt that I or any of my co-defendants are guilty of these charges. Therefore, the court must find all of us not guilty of both charges. Thank you, Judge Gideon.